This is Haystack Help Radio on KLZ 560 The Source. Haystack Help Radio is powered by HaystackHelp.com. Finding help can be like finding a needle in a haystack, but with HaystackHelp.com, finding the needle just got a lot easier.
Welcome back to the show. This is Haystack Help Radio. I am Chris Kane. Our number 303-477-5600. Give us a call with any kind of problems, questions, or complaints. Let us know how we can help you. What can we do for you? That's what we want to know. Give us a call. Let us know. All right, let's go to the phones and talk to Bonnie Bowles. Bonnie, welcome. How are you doing?
I'm doing great, Chris. How are you?
I am good. Thank you very much. Guardianship and probate and wills and trusts. What else do you do that you can make our listeners aware of?
Well, I try to actually avoid probate if possible.
Sure.
I certainly do that if needed, but I try to do the upfront planning, and I work a lot with families with young children. I have a young daughter of my own, 16 months, and so I work a lot with, thank you, I work a lot with those who are expecting even more kiddos down the road or have young kids at home to know, to help them know for sure what would happen to their children if something happened to them.
Mm-hmm.
Both in the short term, such as an emergency, who would actually come pick up your kids wherever they are, as well as the long term, who would raise your kids if you can't. So those are guardianship documents. I do help with getting those in place, along with the other documents and the plan that comes into play when you have assets on the line as well.
All right, well, let's talk about that. And a lot of times I would imagine, like you mentioned, you certainly don't, you try to avoid dealing with probate because you plan for it on the front end. But I'd imagine sometimes you get clients after the fact, that haven't worked with you, that didn't plan on the front end, or I shouldn't say when they've usually passed, but their family members have come to you because the deceased it didn't plan properly, and they say, can you help us now?
Exactly, right. And so when there is a situation where someone didn't have anything in place, or maybe what they did have in place they outgrew, and it didn't quite work out as intended, then the probate court is the process at that point, and I absolutely help families in those cases as well.
All right, well, we'll get into that in a little bit. Let's start with talking about protecting your kids. And again, you've got a 16-month-old. Is that your first?
It is my first. Hopefully, I have a few more.
Excellent. Well, I've got 3.
Sure.
Yeah.
Oh, that's awesome.
So I'm a little ahead of you. My oldest is 13 years.
Okay.
Then I've got an 11-year-old and an 8-year-old.
All right.
Yeah, and I'm done.
Oh, good. I'm into the teenage years.
Two boys and a girl, and that's enough for me. But we've got a list of emergency contacts that we leave around the house for our nanny and for my parents that are over there, my wife's parents. Is there anything else we should be doing or should be thinking of to have around the house in case there is an emergency?
That's a great start, but there is something additional that I would recommend. So if you and your wife or partner are out to dinner and you don't come home at the specified time, ideally the babysitter or whoever's caring for your kids is not going to call the police first. So at least you have those emergency contacts. But the downside is whenever the police become aware of a scenario where minor children don't have their parents, let's say you're in the hospital, even if it's overnight, but if the parents are somehow unable to be with those children, the police are in a situation where they can only leave those children in the care of either a blood relative or, if there's not one, it's foster care or child protective services. So even if your emergency contacts are a blood relative, the downside there without the estate planning documents in place is that how do you prove a blood relation? I mean, I've seen where at the pound, if a family member is going to pick up dogs, they have to show a birth certificate. So you can only imagine what a police officer might require to prove a relationship with children versus pets. So you want to avoid that entirely and just have in place a short-term guardianship document where that you sign as a parent, where you say, I give the following people authority as a parent over my children. And then they don't have to show a blood relationship. They can just show the police officer or whoever else inquires this document, which establishes that legal relationship with that child.
And is that something that you could just leave at the house or leave with the individual, that you've appointed as a guardian, and or the person that's caring for your children whenever you are out?
Actually, all of the above. I would say keep a copy in your home. You would have one document that lists all the available people, or all the people, I should say, that you would be willing to leave your children with. You'd have one at home, and then ideally give every single one of those people a copy as well, because you never know where a particular person may be at any moment, and you want to make sure they have a copy that they could keep in their purse or wallet to produce at any given moment to establish that legal relationship with your children.
And that's quite interesting. You can certainly address this in a will, but you're saying, have a separate document so that you don't have to pull out your entire will just to show who you want to be a guardian of your children if you can't be there for either a short period of time or if something catastrophic happens ever.
Precisely. I say have a standalone document that addresses what happens for short-term guardianship that is totally separate from your will. And the reason for that is what you just mentioned. A will only kicks in if you pass away, so you don't want to have to be digging it up if that's not the scenario you're looking at. There might be in fact, it's much more likely that there's a situation where you would need someone to step in as a guardian for your children before you've passed away. So you want to have that as a standalone document, the short-term one. And even the long-term guardianship provisions, which get buried in a will all the time, I say make that its own standalone document as well, because it needs to serve that purpose of who would actually raise your children if you can't, separate from what happens to your assets under a will.
Mm-hmm. And it's important to have, too, because, if you have, let's say you do have some money and people unfortunately try to get to that, and sometimes they try to get to that through your children, and they think if they can care for your children, they can get that to your money.
Right.
When you're no longer there.
Hopefully that wouldn't be the case, but if that's a concern at all, you want to separate out who's in charge of the kids versus who's in charge of the assets.
Mm-hmm.
Maybe it's okay that it's the same person for your family, but maybe it would be a good idea to separate those two roles.
Yeah, and this is all good advice. And unfortunately, there's too many people that just don't take care of this stuff. They just think nothing's going to happen to me, or I don't feel like dealing with it, because it's sometimes it's difficult to deal with, but it's so important to deal with it, because if you're not here to make those decisions, really, I guess the courts can make these decisions for you.
Exactly. If you're not the one making the decision ahead of time, it is a probate judge deciding for you, someone who doesn't know your family or your family history. Now, they evaluate the arguments from various people who are interested in who gets appointed as guardian or conservator, meaning probate court appointed to handle assets. They certainly entertain arguments, but they have no clue what your history is or what you would prefer as a parent. So just take it out of their hands and go ahead and decide. As a parent, I want certainty about what would happen to my kids, both in terms of who raises them and how they handle their money down the road, and put your plan in place now. I do talks for parents around Denver. I do about 4 a month, free 1-hour talks, all about estate planning, and I'm doing them at venues where nobody seems to be talking to parents about the importance of it. So I do it at venues where there's a lot of expectant moms, some retail stores and yoga places, and I'm the only one talking to moms about this. So to me, it's hugely important being a new mom. To me, it was a no-brainer.
No, it should be, and people need to be better about doing this. They need to take the time and put the effort in and get these documents drawn up. And things change over the years, so it's important to keep on top of it, because whoever you select as a guardian today, that may change in 3 to 4 years. And it may change because maybe you selected a friend that you're no longer friends with, or maybe you selected a family member that has passed, or there could be a number of reasons. It certainly can stay the same, but you do need to stay on top of it, because things change, maybe not year to year, but certainly every few years it can.
Yeah, absolutely. Your life is going to change. There's no question. So you want to make sure, first of all, get the plan in place initially. Get that done so that you know what would happen. And then, at a minimum, every 3 years, sit down with your lawyer and review your plan. That's what I like to do with my clients. We'll meet at the bare minimum every 3 years, and more often than that, if you're part of our membership programs as well that we have available to clients, to keep on top of it and make sure that everything will play out as they intend, and as their kids grow up and establish relationships with other people, it may become apparent to you, they should be our primary guardian in case of our absence. So absolutely update as often as needed.
And a written agreement is really key, and that's what you can do for your clients. A lot of people say, well, I have a verbal agreement, and that should be binding, but it's it really comes down to, are you believable when it comes down to that verbal agreement? If you're one of the parties is no longer there, a lot of people are going to have different ideas of what that verbal agreement might be, but can it still be binding?
Yeah, a verbal agreement is not binding. Really, the most it can be is evidence in front of the probate judge.
Okay.
Yeah, but the judge would have the ultimate say-so in that situation.
Great. And then if you don't specify, let's say, you've got, or in my case, I've got 3 kids, and if I were to pass, all of my assets would go to my wife. But if my wife and I together, let's say something happened and we both were to pass at the same time, does that automatically go to my children?
Without a will, it would automatically go to your kids, yes. If you have a will and it follows the normal order of things to my spouse and then to my kids, it would go to your kids as well. The downside is that your kids being 13, 11, and 8, they cannot legally handle assets left through a will or even without a will. So now, unless you have some sort of mechanism in place to say who is in charge of assets left to minors, which would be something like a trust, if you don't have that, the probate court has to pick out who's in charge of these assets left to these children who are under 18. The court will choose somebody. They have to report to the court yearly. That's called a conservatorship in the probate court. And then as each child turns 18, they'll become the proud owner of their entire inheritance.
Yeah, which would be just a horrible, horrible thing for an 18-year-old to inherit any kind of sum of money.
And not just that, but probate records are public, so you're dealing with a potential scenario where perhaps the creditor or predator is looking at public records. They see how much someone who's about to turn 18 is going to have in their own bank account, and now they're the target of some sort of predatory lending or some sort of scam.
Wow. Yeah, I never thought of that, but that I could see that being a huge, huge problem. And if you take the time and set things up properly, you can then determine and say, okay, this is how I want my children to receive monies that I've left for them. And it's, I want them to get X amount of dollars or X percentage when they're 18 or when they're 25, when they're 30, when they're 40, 50, whatever it might be. And you can spread it out so that it's not just this big windfall at the age of 18 where they're certainly, in my opinion, not mature enough to know what to do with that.
Absolutely. Yeah, you can do all sorts of things. You can say they don't have outright control until they're whatever age you decide, or like you mentioned, stagger it over time. The best part about that all is while it's being held for them and managed by someone that you've chosen, not the probate court, but someone that you trust, if they happen to get into a car accident and are sued for the medical bills, or if they go through a bankruptcy or a divorce, while it's held in trust for them, it is not on the table to be split 50-50 with the spouse or to go to pay off somebody else's medical bills or go to pay off creditors. So that's a huge benefit as well.
And that's just why it's so important to plan on the front end. And a lot of people say, well, I'm not done having kids, so I'll wait until I'm done having kids before I start.
Yeah, I run into that a lot.
Excuse me, I'm sorry, I just had to sneeze.
Absolutely, don't wait.
Yeah, no, you should do it. I mean, really, should you do it as soon as you have your first child? Should you do it even before you have kids? Should you wait until after you're done with all your kids?
Well, I've worked with parents who are expecting their first, so they are on top of it. And then I've also worked with other parents who already have all their kids here, and they may be in the same age range as your children that need the planning in place as well. So I say as soon as it's on your radar as a priority, get it done, definitely. And if you plan on having more children, the estate plan, if drafted correctly, and how I draft mine, it will include future-born children. We identify your current children, but I say that the definition of my child or my children throughout your plan means future-born children as well as children that may be adopted in the future. So you don't have to call me on your way home from the hospital once you've had a new baby, thinking, oh, my goodness, they're not going to inherit anything or not be covered if I don't call Bonnie. I absolutely make sure they're covered, and call me a few months down the road.
The website is willsandwellness.com. Bonnie, thanks for joining us.
This is Haystack Help Radio on KLZ 560 The Source. Haystack Help Radio is powered by HaystackHelp.com. Finding help can be like finding a needle in a haystack, but with HaystackHelp.com, finding the needle just got a lot easier.